Today's presentation is about the meatiest part of what we do in company law. You're in for a good show. Director's duties. Director's duties is the most important thing that one needs to know about, both from an exam perspective, that if you're taking an exam at the end of the year on company law or business law, you're very likely to come across a question on director's duties. And for practical purposes, that most of the trouble that comes in company law comes because the directors have done something wrong. And this is important to know both if you're a shareholder or an investor in a business and if you're a director yourself. So if you do attain the position of a company director, then you would like to know what are the sort of bounds and limitations of your obligations, what entitlements you've got, but crucially, what duties you have in relation to the company, to the shareholders and the outside world. And we have come across a number of debates already as to why this stuff is important. Primarily, we have information on what happens when things go wrong. So you remember all this debate about powerful CEOs that do stupid stuff and then tank their companies, right? We've talked in the past about Robert Maxwell and examples of corporate mismanagement that had led to a lot of people losing their jobs in the end. And we have a great deal of kind of current examples of mismanagement, or at least it looks that way from the outside, like what Mr. Musk is doing with Twitter and some of these other companies. There seems to be something off about people who attain a position of power and then exercise that power to dominate the way a corporation is run without any consultation with anybody else. So understanding some basics about corporate governance and what is required by law that the corporate board does, and also what is considered best practice in relation to running a company, can offer some framework to people who are becoming company directors in how they can actually operationalize their duties and figure out what to do. So the examples that I discussed are people not doing their job properly. It's both an issue with the individual, but it's also an issue with defective corporate governance mechanisms in the company. A company will most of the time involve a great deal of people. So there are people who stand to lose out when things get off the rails. So we need to think about what can be done to prevent this from happening. We've already discussed that English law is not very pushy. So in terms of corporate governance arrangements, English law is not a system that it tells corporations how they should organize themselves, how they should organize the corporate board, how they should communicate, and how the shareholders should make decisions and so on. Beyond a basic framework that is built into the Companies Act, then there's a great deal of leeway in how companies actually behave internally. So it's the articles of association that are going to determine how the board takes decisions, how the shareholders take decisions, how they communicate with each other. I hope everybody is by now familiar with the distinction between obligatory, like mandatory, and default versions in the Companies Act, right? That there are some stuff in the Companies Act that you cannot deviate from. It's the same for everybody. And there are some stuff that says, here's the default position unless the company wants to do something else. So all the flexibility comes from these default provisions of the Companies Act, where people are given the opportunity to choose to do something different. So if we come back to the idea that you have a corporate board, the corporate board is authorized by law to run the show, cannot really be amended by different provisions in the Articles of Association, because the law, both in the statute and in case law, does say that the directors are the bosses. So you can arrange for more consultative practices in your Articles of Association, but you cannot undo this basic arrangement that the board of directors will be the body that makes decisions. Within the board of directors, though, you cannot have one individual that makes all the decisions and everybody goes to bed, right? Still, it's supposed to be an organ of the company. It's a community coming together to do stuff. So if you have more than one director, there should be a way that the others have input, because it is, in fact, required by law. Even though English law is not terribly prescriptive about organization, there are some basics. Ultimately, we discussed that the shareholders, if they're sick of the bosses, they can do what? So using section 168, the shareholders can dismiss the board on an ordinary majority. That's important, because if you're thinking, what's the worst thing that can happen to me as a director? And the answer is, well, you can get fired, then that should help concentrate the mind. The weakness with this is that usually by the time the shareholders figure out that you've done a terrible job, you've done the terrible job already. So we want some stuff that are prospective as well as punitive. It's okay to say that if the shareholders figure that the board is doing a terrible job, they've got the option to remove them, and they will always have this option because this is a mandatory provision. It cannot be taken away. But wouldn't it be nicer if corporate boards actually did a good job so they don't cause harm to the company, so the shareholders don't find out and then decide to get rid of them? So a lot of the things that I'm going to talk about today are about kind of front-loading this and making sure that things are run properly at the beginning before people get into trouble. So let's talk about the duties of the directors. These are in Chapter 2 of the Companies Act of 2006. There's quite a few of them, and to be honest with you, they could lay it out in a clearer way. Because if you go through the sections there, it isn't immediately obvious what they're talking about. So it's worth spending a little bit of time to figure it out. But the first question is, to whom are these duties owed? So to say that the directors owe duties, do they owe duties to the shareholders? Do they owe duties to the company? And what does this actually mean? The duties are owed to the company. They're not owed to individuals directly. I think this has some important consequences. If you are to complain that the directors are doing something wrong, you need to frame your complaint in that they're doing something wrong in relation to the company. They're breaching the rules or they're making decisions for the wrong reasons, but the damage needs to be common. It is not really possible for an individual shareholder to say that the directors are in breach of duty because they're taking actions that affect one particular shareholder in a particular set of circumstances. There are other avenues that somebody in a minority position can complain that they've been treated unfairly, but this isn't it. So when we're talking about duties, we're talking about the board of directors as a body or an individual director that has actually done something wrong towards the company. Maybe the effect is not felt in the same way by all the shareholders, but the victim of whatever is being going wrong is the company or the shareholders as a community, not as an individual. Now, could we argue that they owe duties to people external to the company? So that part is horribly mislabeled. You have a provision in the Companies Act that says when they're taking, and we're going to see this in a moment, when they're taking decisions in the interests of the company, the directors need to consider also the interests of stakeholders. Do we have a definition of who is a stakeholder? It could be creditors, right? The people that have given you money and you're meant to repay. If I'm just interested in it, or, I'm interested in fashion, but I've never bought a Dior outfit, right? So that doesn't make me a stakeholder because I'm a little bit removed. A stakeholder is anybody who's affected by the behavior of the corporation and is not already an insider. Insiders are only the directors and the shareholders. These are the only groups of insiders. Everybody else who's affected might be a stakeholder. Employees are not, they work for the company, but they're not insiders in the sense of decision making. So employees are directly affected about what happens, but they don't get a say in what's going on most of the time, so they're stakeholders. The customers, anybody who lends them money, it could be trade creditors, but anybody who's waiting to be paid effectively. And it could be a large number of suppliers, people who are associated with them, whose own existence is dependent on the health of the company, but again, they don't have a say in how the company is run. If you're a farmer around here, you probably sell all your produce to the big supermarkets. You're dependent on them buying your produce, otherwise you don't have a business. But you got no control as to how they decide to buy stuff, use stuff, what prices they're going to pay. So you're in a position of weakness, and there's nothing you can do about it. By that measure, you could argue that the town where a business is operating, especially if it's manufacturing, could be one of the stakeholders because there's an impact on local employment. There might be an impact on the local environment. So again, these are people who are affected by the behavior of the corporation, but they don't really participate in decision making. So these are the groups of stakeholders, but the duties of the directors are not owed to the stakeholders. The duties of the directors are owed to the shareholders. There might be mechanisms in the law that create certain obligations to outside groups or the state or authorities in certain circumstances, but the baseline rule is that the duties are directed towards the owners of the company, who are the shareholders. Do you need to be officially a director to be subject to those duties? No. You need to be somebody who is in a position of authority within the company. So when we were talking about corporate governance, you might have figured out that there are various types of directors. It could be that somebody is officially appointed and externally projects as a director and manager of the company, but there could be other people who actually exercise influence and control over how the company is run that don't have officially that title. And there are various provisions in the law that cover people who operate like this. If you look at Section 250, 251 of the Companies Act, it talks about shadow directors, it talks about other people to whom the management of the company normally looks at for advice. The director's duties will cover anybody who is officially appointed as a director, but will also cover people who are in this kind of background position of control, even if they don't officially have the title. Now, what about people in the management chain? As we said before, being a company director is holding an office, is not being an employee. It could be that a director of the company is also employed to be the CEO. Or it could be that there is an organizational structure and a management chain where people are tasked with particular responsibilities. These people do not owe directors' duties if they're not officially directors or if they don't operate as shadow directors. But management always reflects the wishes of the board of directors. So even though somebody has been appointed as a manager, there will be a director behind them who's responsible for that particular operation. So the director will always be responsible, and even though they have delegated some of their duties to a professional manager who is simply an employee. So there's always a line of connection and authority that goes back to the corporate board. What is the answer to this? Why is this important? It's important because you cannot say, it's not my fault because some professional manager decided to do something wrong. Since the directors have a continuing obligation to monitor and control, they cannot get away with it simply by saying they had passed on operational responsibility to somebody down the management chain. And in terms of time frame, the duties can survive the termination of somebody's appointment. Again, it is not as easy to escape your obligations by saying, well, this is going wrong, I quit. So from now on, it isn't me. Because you will still be responsible as a director for whatever you did that was wrong while you were a director, and that liability will chase after you even after you left the company. So from the point that you officially resign, then you're not responsible for future actions of other directors, but if you've already done something in the past that's wrong, then they will chase after you, even though currently you're no longer a director. So what are the actual duties? Right? Because we said there are all these duties and obligations, but what is it actually that is required of people? One of the key duties is to exercise a reasonable care, skill, and diligence. Meaning what? Meaning that you cannot suck at the job. Now, this is interesting because you might get the impression that if there is a duty to exercise reasonable care, skill, and diligence, this actually makes being a director equivalent to a job with a particular job description. But we had said that there are no objective criteria that you need to fulfill in order to become a director. What's the minimum age to be a director? So that's the only criteria. So long as you're over 16 years old, then you can become a company director. So clearly, if you appoint a 16-year-old to lead a company, maybe they lack the skill, care, and diligence to carry out that role. So how do we understand this? Is this an objective standard, meaning that there's a kind of baseline expectation of behavior, or is it a subjective standard? We look at the person, and depending on what they're able to do, so long as they operate at the best of their ability for the level that they're at, then it's okay. Now, having a subjective standard can be a problem, though, because if you're a complete talentless idiot, then you could do your best in being a talentless idiot and the results are still going to be bad. So if you get somebody who really has no capacity whatsoever and their record demonstrate that everything they touch turns to dust, so if you appoint them as director of your company, they're probably going to ruin the place, but they have performed to the best of their ability. They just don't have any. Yeah? So that cannot really be a good idea. So if we're looking at the duty that's in section 174, duty to exercise reasonable care, skill, and diligence, we need something a little bit more, or some sort of combination between an objective criteria and a subjective. So I explained why you don't want subjective, because somebody who's completely clueless would actually not be breaching the duty by continuing to be clueless. On the other hand, you cannot have a purely objective criteria. Objective is that you have a set standard of expectations regardless of who the person is. If the criterion is subjective, you got no expectations. It depends on the person. Well, that's the thing that I'm trying to investigate, right? Because for you guys, if you say, if we have a purely, look, I'll put it this way. We don't have a subjective standards in the way we assess students. We have objective ones. Meaning we have a set of learning outcomes and we have a certain expectation on performance that you have to meet in order to pass. So it doesn't matter what your personal capacity is, there's a threshold that is set and is the same for everybody. If we had a subjective standard, then we would say, so long as you demonstrated some effort, you did the best of your ability, then that's great. But the best of your ability could be 70% or it could be 30%. So a standard that depends on the individual could actually be very, very low. A standard that is objective is set at one level, and then it doesn't care whether you perform a lot better or you perform a lot worse, so long as you meet that minimum. But what I was about to say is that an objective standard might not actually be a great idea, because it might set lower expectations than what we want. So if you set your objective really, really low, and you say just a reasonable person who has finished school, then, a 16-year-old might fall below this, but this is really very low expectation for somebody who's, say, a senior manager somewhere and has been doing it for 20 years, right? You should expect better of them. So you cannot equate everybody down to the 18-year-old. So the law achieves this by having a combination of those standards. It says there's an objective standard of care, skill, and diligence for everybody. So there is a bare minimum. So you cannot excuse dreadful performance by just saying, I'm a clueless idiot. But if you know better, then the standard is elevated depending on your personal ability. So what we have now is an objective standard plus. The plus means we will expect higher of the people who actually know better. So there's an objective baseline and then a subjective criterion that can get higher depending on who the person is. That way, we don't excuse really incompetent behavior. Nobody's allowed to do this. But if you are a seasoned operator and a kind of senior executive that get paid a lot of money, or at least they think they're worth a lot of money, then we expect them to operate at that higher level. So it's not an excuse for somebody at the top level of the expectation to say, I performed as well as your average 16-year-old. Because due to their background and experience, there's a higher expectation of performance from them. So you're going to see this if you read the details of what is in section 174. And this comes from case law that I developed over the years. So this 174 is the section that is entitled Duty to Exercise Reasonable Care, Skill, and Diligence. What the section does is that it basically puts in statutory language what had been arrived at the case law before this. So we have a lot of cases where the courts actually try to explain how you have an objective base and then a subjective top-up to the expectation on the behavior of company director. Now, an interesting or an obvious question is what happens if you breach that duty, if you perform incompetently? So if you fall below the expected level, wherever we set that level. You can compensate the company if the company has suffered any loss. And that's the same issue with everything else. If you remember from contract law, you don't claim compensation simply because you're the victim of a breach of contract. You can only claim compensation if you have suffered loss in terms of money. So if you cannot quantify your loss in money, then you got nothing to ask. A bad business decision will not necessarily be a breach. Violating the rules will be a breach. So if they violate the Articles of Association, it will always be a breach. But if the company has not suffered any loss, there's nothing to compensate for. So they took the decision to sell a company asset without getting permission from the rest of the board or without getting permission from the shareholders. And the Articles of Association said you cannot sell something major without the shareholders approving it first. It needs to be written in the articles because there are no limits to decision making generally by themselves in the model articles, apart from certain categories that the Companies Act requires some consultation. But if the company wanted to restrict the ability of the directors to do certain things, then they need to amend the model articles to put that in their Articles of Association. So if it says you cannot sell a major asset, right, and a major asset is defined as something that's worth more than £5,000, and one of the directors comes across somebody who says, I absolutely need a van for tonight and I cannot find anybody to rent me or sell me a van and I'm willing to do anything, I'll pay whatever to get a van. I absolutely need to have one. And they've got a company van that's worth £6,000 for which they would need to get permission to be able to sell it. And instead of getting permission, the director says, I'll sell you this van for $10,000 right now. So this is a violation of the rule. So it's a breach of duty. Not respecting the company's rules is a breach of duty. But the company hasn't suffered any loss. In fact, the company made a profit because the market value of this van was not above 5,000 and they sold it for 10. So they can actually go now and buy another van for 5, that's going to be the same van and it's not a problem, right? And they made a 5,000 profit. So you can have situations where the directors have breached their duties, but this has not resulted in any loss to the company. So then there's no remedy to this. The only remedy to this is if the shareholders disapprove of the directors breaching the rules, they can dismiss them and replace them with somebody else. But they're not going to be asked to pay compensation to the company unless the company can demonstrate that they suffered some loss. Same as contract. There is this idea, this principle that's called efficient breach of contract. What does that mean? It means you can choose to breach your contracts. And so long as you compensate the other party for whatever loss they're suffering, it's okay. But you're not allowed to beat people up because you disagree with them. And you're not allowed to smash something because it offends you, because that would be a criminal offense. But you're allowed to breach a contract, not perform on a contract, and so on. Somebody hires me to come in here and deliver a class. At the same time, somebody else comes along after I've signed this contract and I'm committed to coming here at this hour and delivering this class. Somebody else comes and says, if you come and teach for us Monday morning, because, our teacher is sick or whatever, we'll pay you 3 times as much as these guys are paying you. I could choose to go to the higher thing and breach this contract. And then, obviously, I'm not going to ask for payment. If they had paid me already, I need to return the money. If they need to hire somebody else at a higher cost, I still compensate them. I may have to compensate them for that, but I'm allowed to do it. So there's nothing that forces me to perform on a contractual obligation. The only obligation I'm going to have, if I'm pursued in a civil court, will be to compensate the party for whatever loss my breach has caused. Same thing here. If a director chooses to breach their duties and there is no financial consequence on the company, there's no loss, then they're not going to have to pay any money. Then the question is, are the shareholders happy to let them get away with it, or do they choose to dismiss them, taking the fact that they've been in breach as a valid enough reason to dismiss them? To be honest, they don't need a valid reason. They could just say, we changed our minds about you, which is also fine. Normally being in breach of duty is what leads to discussions about whether somebody is a suitable person to be in the board of directors. The other duties come under the label of fiduciary duties. You guys know why we use the term fiduciary, what it means? If you say that you've got there are equitable considerations, it has to do with justice and achieving justice and fair outcomes. If you're talking about fiduciary duties, you're talking about duties that exceed the contractual arrangements. So you've got a duty of care towards somebody for some reason. It implies a closer relationship that goes beyond the strictly money relationship. So these fiduciary duties are because there's a duty of fidelity and care that the directors owe to the company. The reason why they say this is because these are a little wider ranging than just a checklist of obligations. If you tell people you need to act within your powers, that's pretty specific because that's the paperwork. But if you tell people you need to act with somebody else's interests in mind, this is a little bit broader. So because it leaves flexibility and room for interpretation. So you're going to find a lot of discussion about these fiduciary duties, but if you're trying to answer some sort of problem question that contains somebody who has done something seemingly inappropriate, I wouldn't start with a definition of this, and I wouldn't start talking about fiduciary duties. I would stick closer to the provisions in the statute, because the way these concepts are presented in the textbooks and in the case law, they tend to be a little confusing. But if you go from the sections in the statute, it becomes a lot easier to identify what has gone wrong. Because the statute gives you a list. Here, they're obligated to do this, they're obligated to do that, they're obligated to do that. So figure out which one of the obligations seems to be violated, and then if you want to label this as a fiduciary duty or something else, you can do that later on. That ensures that you start from something specific, so you have the correct section that you're discussing, and then you have all the discussion. As opposed to starting with, let's check if this director has breached the fiduciary duties, which could be like a gazillion different things. Right, so let's have a look at things that come within that, like these categories of obligations. The most obvious and the easiest one is that they have a duty to act within their powers. So they cannot do whatever they want simply because they've been appointed as directors. They're meant to stay within the powers that have been given to them. So this is in section 171. That's why I'm saying, because the sections have quite a descriptive heading, it's always easier to start from the statute and figure out, okay, this person has been accused of having done something wrong. What does this look like? Does it look like they're doing random stuff, for instance? So I have a section here that says act within your powers. If you're doing random stuff, you seem to be breaching that. They must act in accordance with the company's constitution. If the articles say you don't take a decision on this thing without asking the shareholders first, and the director just took the decision, as in the example I gave you, then they are in breach of section 171. Because they did not follow the procedure set in the articles in order to do something. So if a director files paperwork with Companies House to dismantle the company without asking the shareholders first, then they are in violation of... So the articles will be whatever it is for this particular company, either the model without any amendments or the model with whatever amendments, and these are publicly available documents, so you can go to Companies House and download them. So there's no debate. Nobody should be confused as to what the articles say. You can get them and you can see what they say. So obviously the person who should have a good look at them is the director, because if they start doing stuff at random without looking at the articles, then they run in danger of some violation. So if they don't respect the limitations to their powers set from within the company, then they are in breach of their duty. And also, they're obligated to exercise the powers that they have for the particular purposes for which they were given those powers. You can have, as a company director, a credit card that's got your name on it, because otherwise it's not going to work, but it is the company's credit card. So it's the credit card that's linked to the bank account that belongs to the company. You're supposed to use that credit card for company business. So if you use it to buy yourself like a Black Friday deal for yourself, then you had the right to use the company credit card as the director, no problem, but you used it for the wrong purpose. You were not using it for the purpose for which this power was given. You used it to purchase yourself a gift. So that is a violation. So not only you're supposed to do stuff that you're authorized to do, but also you're supposed to do these things for the authorized purposes. Now, 172 is when it gets a little bit broader and contains some concern for the interests of stakeholders that we mentioned earlier. So 172 is the duty to promote the success of the company. So directors are obligated in good faith to promote the success of the company for the benefit of the members. They work for the shareholders. This is what this means. So this offers an answer to the question, what are they supposed to be doing? Who do they work for? Who is the boss? So section 172 says that ultimately The boss are the shareholders. So when the courts have tried to define what do we mean by company success, the answer has been financial gain for the shareholders. It does say, there's a kind of note to this section that says, while they're doing this, promoting the success of the company, they're supposed to have regard to long-term consequence of their decisions, the interests of the employees, the interests of suppliers, customers, and others, the community, the environment, maintain high business standards, act fairly amongst the members of the company. So this incorporates in this provision some concern for the stakeholders. What do you think is going to happen if a director says, I only care about my shareholders, I don't give a damn about anybody else, therefore I'm not considering the interests of employees, suppliers, customers, business. I'm not doing that because my sole focus are the shareholders. It is a breach because the law says, the way we define it is that you need to think about these things. Saying that I am not going to do it, it's a breach of 172. Because 172 says, when you're promoting the success of the company, you have to consider it. But if the director says, I've considered it and I don't want to do anything about it, so I'm taking actions only when they make money for my shareholders, and even though I've considered the impacts this have on employees, creditors, the environment, the community, I'm not actually going to do anything about this, then they're fine. Because the section says you need to think about it, it doesn't say you need to take certain action. And in any event, the only people who are in a position to kind of discipline you if they think you're not doing a good job are the shareholders themselves. So if a director says, I consider these things as I'm expected by law, but I don't take any action, it's up to the shareholders to say whether they agree or disagree. If the shareholders are cool, nothing happens. If the shareholders are not cool, then they can dismiss this director or this board and replace them with somebody else. That's why this should not be interpreted as a provision that obligates corporate boards to think about interests of stakeholders, because it isn't very strong. It's a very, very weak provision. If you wanted them to consider the interests of stakeholders, then you would have attached some penalty when they decide to do nothing about it. So this is a common theme in kind of essay questions around this area because it causes a great deal of discussion whether this provision is enough in incorporate things like corporate social responsibility or concern about stakeholders in the environment, or whether it's not. So you will find evidence in the literature that point one in the other direction. My personal view is that it's quite weak because it does not necessitate any action. Come back to it. Company success is very much money making for the shareholders. The only way you can improve this is if you're thinking not just the current shareholders but future shareholders as well, because you should be thinking not only making money for somebody who has the shares now, but keeping the company alive and successful for the people who are going to be shareholders in the future. What happens if you're in a group of companies? You don't care, because if each company is separately incorporated and each company has its own corporate board, so the emphasis is on the board that you're running. So if you're a director, you're looking at your own company. Maybe you're a subsidiary in a group, and maybe the group has a strategy and a plan. It's cool and it happens. It could be that the parent company is also the sole shareholder, so there's an alignment of interests in that regard. But when you're making decisions, the legal obligation is to think about what you're doing as a corporate board for this entity, not for the parent or other subsidiaries or anything else. Another one of the duties, so far we've seen staying within the powers, acting in the interests of the company. Now we're getting to a duty to exercise independent judgment. So you see, when I said earlier that you're allowed to have a management chain and other people in the organization that may or may not be directors, but this does not excuse you from doing your job, this is why. Because in section 173, it says a company director must exercise independent judgment. And this means that even when they have delegated to other people, they have a continuing obligation to oversee and consider what these other people are doing. So let's wrap this up. What have we seen today? We've seen that the directors owe their duties to the company to the shareholders as a community, not to individual shareholders one by one, that they have overall a duty of skill, care, and diligence, which is expressed in Section 174, which is an objective standard with a subjective top-up. So if you know better, you will be held to a higher standard. And then we started to investigate the broad array of other duties, starting with 171, which is the duty to act within the powers, 172, which is the duty to act in the interests of the company, and we defined interests of the company as mostly financial. And finally, the duty to exercise independent judgment, meaning that you cannot subcontract your decision-making to somebody else and then go home.